Your Lordship. Yes. Lordship, with the due consent from my counterpart, my lord, I beg to mention item number 7, my lord, wherein my name is, I am not with the case, my lord, but Mr. Dor today, my lord, in morning has instructed me. He is out of station. Mr. Chakraborty is also, my lord, suffering from brain stroke. He cannot speak. That's why, my lord, matter may be fixed any date, my lord, next week, my lord. On 5th or, my lord, December 5th or 7th.
The 2012 matter.
Lordship.
Then
Kindly, my lord, a little bit of accommodation, as per instruction of my client, my lord.
a prayer for adjournment has been made in this case on the ground that the briefing council is suffering from some critical ailment, as a result of which he is unable to come to court today. Under the circumstances, the arguing counsel, Mr. N. Ross, is unable to conduct the hearing of the matter today. It appears that even the respondents' counsel is unavailable. In view of the above, although this is a very old pending matter, yet taking note of the grounds on which the prayer for adjournment, on which the prayer for adjournment has been made, the same stands allowed. Hearing of this matter stands adjourned for 2 weeks.
My lord, on 5th, my lord.
No firm date, 2 weeks. No firm date.
Obliged.
Obliged. I am a people from Apex Bank Lodge.
Yes.
That's when I wanted to take care of the lodge.
Mr. Sanso is present on behalf of the respondent.
Obliged.
Adjournment, adjourned for 2 weeks. That's it.
Me, please, Your Lordship. I beg to mention a writ petition for listing in the orders section, Your Lordship. Matter was last listed in July and thereafter it has not been listed.
Next week.
Yes, Your Lordship.
Okay. May please, Your Lordship, I beg to mention item number 2 of today's list, my lord. I'm going to file my affidavit today, my lord. Only. I have taken the consent of the other side also.
Ms. M. Kataki, learned counsel for the respondent number 2.
Lordship will pick the matter, my lord, next week, my lord. Since there are 2 consecutive orders, my lord, that has not been followed.
Is that she is in the process of filing affidavit on behalf of our client during the course of the day. Mr. B. Chetri, learned counsel for the petitioner, has expressed urgency in the matter. In view of the above, office to tag the affidavit of the respondent number 2 with the record of this case and list the matter again after a week.
Lordship, kindly pick.
After a week. After a week.
May
As
I-
a fixed item. As a fixed item after a week.
as people.
Obliged, Lordship.
May I please, Your Lordship? Lordship, I beg to mention WC 5947 of 23. Last it was listed on 10/10/2023. But all the matters
So
of
you
this-
request the registrar to list it. Make a request to registry.
Obliged.
All matters can't be mentioned like this. Yes.
May I please, Your Lordship, with the consent of other side, Lordship, I beg to mention item number 12 on behalf of Deputy SGI. He is not feeling well, Lordship. He has not come to the court, Lordship. I have taken the consent.
My lord, I am from outstation lawyer. If my lord is kind enough, is it possible to fix this Tuesday? Till Tuesday, I am in Guwahati, my lord.
All right. Mr. T. Das, learned counsel for the petitioner, is present. However, the learned CGC appearing for the respondent submits that the DSGI who has been engaged to argue the matter is unwell today. As such, a prayer has been made to pass off the matter for the day. At this stage, Mr. Das submits that since he is an outstation counsel and will be available in Guwahati till 28/11/2023, the matter be posted again on the said day. First of all, since the prayer is not opposed, same stands allowed. Register to list this case again on 28/11/2023 as a fixed
My
item.
lord, one humble submission. Earlier, lot of, these postponements took place in this subject matter. If my lord is kind enough, somebody else can appear, he can appear. It's
Lordship,
small
that
issue, part
will
order
make
is
clear
there.
that if the
So many
if the
times, my
arguing
lord, I
counsel
came and went back
is
empty-handed.
unavailable on the next date, then an alternative arrangement be made. For conducting
Deeply
the
obliged, my
hearing.
lord.
May I please, Your Lordship? I pray for listing of a contempt matter of the year 2018 in the order section, Lordship.
Why it has been not listed?
Lordship, the matter last came up on 11/9/2023, Lordship, but
there's the opposite counsel has to bring instructions in relating to the compliance of the order.
Next week.
Much obliged, Lordship.
May it please your lordship. Lordship, I beg to mention WPC number 2188 of 2022 for listing it for final disposal. Lordship, the matter is of promotion of a government employee and all the pleadings have been completed.
First week of January. First week of January.
Obliged, lordship.
May I plead, my lordship? My lordship, I beg to mention writ petition number 5901 for admission, my lord. An earlier date may be given, my lord.
First week of January.
Much obliged, my lord.
May I please, my lord? Make a mention for writ petition number 4620 of 2023. The last order was on 14th August and the returnable date was upon the motion, returnable date was 6 weeks. Now it's more than 12 weeks, my lord. It has not been listed yet.
After 2 weeks. After 2 weeks.
Obliged.
Put a note.
For motion item 1.
Item number 1, 3 and 4 are similar matters. In 3 and 4 matter, there are orders that the matters will be taken up for disposal. What had happened? The petitioner had participated in the selection process and they were not included in the final select list because
Use the mic, please. Yes.
my lord, yes, they had participated in a selection process, my lord, and they were not, although being OBC category candidates, they had secured more marks than the last general category candidate, but were not selected because the respondents had tried to assert that we had availed the relaxations available for the state of Assam in height and chest. And this honorable court has already held that taking such a relaxation will not debar them from coming into the unreserved category quota. Now, Lordship's earlier order is at page 59. Lordships had allowed the writ petition on a consensus when they admitted that this was a covered matter. Item number 1, 3 and 4, my lord, had come up earlier. We had given them the judgments. There was a concern that it is covered, my lord. So perhaps it can be disposed of on similar terms, my lord.
They have submitted the Gaurav Pradhan judgment, lordship. Otherwise, there was no vacancies. This judgment was given by them, lordship.
In the earlier order also, my lord, which we have annexed to the writ petition, this submission was made and lordship had taken care of that by providing that they can be accommodated in any CAPF where the post should be available. Otherwise, Gaurav Pradhan, my lord, goes on to say that if required, supernumerary posts have been created because reserve category candidates have been denied. So if required, till they can make an accommodation in the normal vacancies whenever they arise, so supernumerary posts have been created. But I had given a copy in the other judgments, the other writ petitions, a copy. The situation was exactly the same. OBC category candidates were denied by not migrating to the unreserved category. If lordship would have the last page, my lord. Para 51, my lord. Para 50, my lord. Of the judgment, para 50. On the question of existence of vacancies, although the learned counsel for the appellant submitted that vacancies are still lying there, which submission, however, has been refuted by the learned counsel for the state of Rajasthan. However, neither the appellants had produced in details of number of vacancies, nor has the state been able to inform. We thus, adjusting the equity between the parties, issue the following directions. The appellant writ petitioners who per their merit were entitled to be appointed against unreserved vacancies, which vacancies were filled up by migration of SC, ST, OBC candidates who had taken relaxation of age, should be given appointment to the post. The state is guided to work out and issue appropriate orders for appointment to such candidates who were, as per their merit, belonging to general category candidates entitled for appointment, which exercise shall be completed within a period of 3 months. The state shall make appointments against the existing vacancies if available. In the event there are no vacancies available for the above candidates, supernumerary posts may be created. For adjustment of the appellants, which supernumerary posts may be terminated as and when the vacancies come into existence. In the earlier order passed by lordships, lordship had directed that wherever vacancies in any of the CAPF is available, the petitioners could be adjusted. That is at page 60, my lord, of the writ petition.
Yes.
Second last paragraph, my lord.
So how many petitioners are there in this case?
My lord, in the first writ petition, there is one. In the item number 3, we have 2, and item number 4 also 2. Total 5 writ petitioners are there.
All of them belong to OBC.
My lord, in item number 3, it is SC. In item number 4, it is OBC. Item number 1 is OBC. 3 OBC candidates, 2 SC.
এখানে নোট করেছি। Item number 3 SC.
As item number 3 is SC, item number 4 is
Item number
OBC.
3, how many candidates? 2.
2.
2 candidates SC, and then item number
4, 2 candidates OBC.
item number 4, 2 candidates OBC.
Item number 1, 1 candidate OBC.
Item number 1 candidate OBC.
OBC.
এখানে, very good. So this they were granted relaxation in
Height and
measurement of
chest.
height and chest.
Chest, which is available for the entire state of Assam. Unreserved, reserved, everybody could avail that height, that relaxation. Now, when we secured more marks than the last unreserved category candidate selected, taking a cue that we had availed some relaxation, they wanted to deny us.
All the cases, you secure more mark than the last.
General
unreserved.
category, yes.
So we'll dispose it of then.
My lord.
Modular order DSO, but you can change for you. Don't heard Mr. R. Majumdar, learned counsel appearing for the writ petitioner. It item 1 of, also heard Mr. SS.
I appear in item number 1, my lord.
Item number 1,
Mr. G. Pegu, learned CGC, appearing for the respondents. Item number 1, Mr. G. Pegu, or Baki total.
I am appearing in item number 3, in my place appear 4.
नाम के अपने नोट कोई लोग item 3 Mr. SS और Mr. R. Borwa. S. Borwa. The writ petitioner hearing is a candidate belonging to the OBC category. Stop. In response to the advertisement notice, same date,
Same
21/7/2018, issued for the purpose of recruitments being conducted for filling up the posts of constable, bracket general duty, bracket close, in the Central Armed Police Forces, bracket CAPFS, comma, the petitioner had submitted his candidature and had also taken part in the selection process. However, upon conclusion of the selection process, the name of the petitioner did not find place in the select list, although he had scored more marks than the last selected stroke appointed unreserved category candidate. First up. According to the petitioner's counsel, the benefit of reservation was not extended to the petitioner on the ground that relaxations were already granted to him on account of the measurement of height and chest. However, Mr. Majumdar submits that such relaxation was given to all the candidates belonging to northeastern region of India, and therefore the same could not have substituted the relaxation which was statutorily available to the petitioner as an OBC candidate. Mr. Majumdar has also invited the attention of this court to the decision of this court rendered in the case of Manoranjan Roy and another versus Union of Indian Others, bracket WPC number 3468/2023, and a series of other similar writ petitions, wherein the grievance of the petitioners, writ petitioners were redressed with a direction upon the respondents to issue order of appointment to the petitioners as expeditiously as possible. Mr. Majumdar therefore submits that a similar order can be passed in the present case as well. Mr. G. Pegu, learned CGC, has submitted in his usual fairness that the case of the petitioner would come within the ambit of earlier orders passed by this court, and to that extent, he does not resist the prayer of the petitioner. However, at this point of time, vacancies may not be available so as to accommodate the petitioner, and therefore a writ of mandamus may not be called for. The said submission of the learned CGC has been countered by Mr. Majumdar by placing reliance on a decision of the Supreme Court rendered in the case of Gaurav Pradhan and others versus State of Rajasthan and others reported in 2018 bracket close 11 SCC 352, wherein the Honorable Apex Court had held that if the appointment orders to the reserve candidates were denied without any valid basis, they should be appointed if necessary by creating superannuary posts. After going through the decision of the Supreme Court rendered in the case of Gaurav Pradhan and others, the next para, Supra, I find that that was also a case where the petitioners who were a part of the merit list were entitled to be appointed against unreserved vacancies, which vacancies were filled up by migration of SC/ST/BC candidates who had taken relaxation of age. First of, having found that the petitioners could establish their right, the Supreme Court had made the following observations and directions. Page 50, para 51 to 52. That's the court going. In view of the above, this writ petition stands disposed of by I think before line to be explained Gaurav Pradhan in that case. The Supreme Court had taken note of the fact that the candidates who were found to have been selected and were entitled to appointment on the basis of their merit were sought to be denied their orders of appointment by taking the plea that vacancies were not available. First of writ petition stands disposed of. Instead of one petitioner, two about day over disposal.
I'm obliged.
Also, orders of appointment be issued as expeditiously as possible, preferably within 6 months. However, if vacancies are not available, then if necessary, superannuary post in the light of the observations made in the case of Gaurav Pradhan be created for addressing the claim of the petitioner or double as a petitioner. With the above observation, writ petition stands disposed.
Supplementary list for admission.
I prepared a note, points for consideration, and also the gist of the case. I'll submit later on. Let me tell your lordship and very precise the matter of. I'll not argue on based on the factual part. On the basis of the regulation, I will argue. Let me start, my lord, what was ever the case and how this petitioner was implicated in this matter. Now, there was the inspection in respect of 6 accounts, my lord, in question. My lord, loan was applied by 3 different entities and they applied. While applying loan, my lord, 6 accounts, my lord. This
before you proceed, Mr. Das, what is your client is retiring, you say?
My client retiring on 30th.
So what is, you want an order before 30th?
That's what.
What is the order you are seeking?
No, we want that this penalty which has been imposed against us, that penalty should be set aside. How they issued a major penalty on us, my lord, major penalty.
All right, but if the court hears the matter, that means the judgment will have to be delivered before 30th. That will not be possible.
That's why I'm saying.
That will not be possible. Because
I understand. That's why I said.
Because personally, I am traveling next week. and will perhaps not be there available before 30th. Delivering judgment may not be possible.
Right, I understand, man. Whichever it's convenient.
I thought you wanted some interim order or something. No.
Interim order, there is no question of interim order, my lord. Because some interim order was passed by the court in respect of my promotion, but that's, my lord, immaterial because the handle which was given by the court, by this court, and already two has been already selected. And they are appointed. One has retired, once they are continuing, but I am retiring on 30th of this month. I thought that is just it's wastage of arguing on that point, my lord. So I thought that let me argue on the main point, which a major penalty has been imposed on me. But the only one point, my lordship will, I know, understand the difficulties because your lordship is traveling. Only what point is troubling? Only one point, if that can be answered, my lord, there was just, my lord, if your lordship, 6 accounts. That means when a loan is disbursed, my lord, there is a committee. I am also one of the member of that committee. I am the chief manager now of Grameen Vikas Bank. So, my lord, when a loan is applied, there is a committee which doesn't decide by only one man, committee. Now, this committee looks over the entire papers, documents, and ultimately they said, yes, fit case for sanctioning of the loan and disbursing. Now, all this was done, and it was also sanctioned by the higher authority on the basis of all the documents and the disbursement. Now, when a disbursement is made, my lord, there is an internal committee of the bank where they inspect. Inspection is done by the internal committee. They looked after documents, how it has been done, in what manner it has been done, all that has been done. And there are 2 inspection reports in respect of all these accounts. And while looking, the internal committee, they said there is no lapses in issuing a sanction and disbursement of loan, no lapses. So once there is no lapses, and that's the staff accountability policy of the bank, University 2017, 2021, as per 10.2b, that's the only point why other points, 10.2b says, once the staff accountability policy of the bank, there is no lapses on a report. There is no question of going further ahead and issuing a charge sheet, which has been done in the instant case. This is one matter. And there is no answer either by the inquiry officer or by the presenting officer. They just said that DO will decide, DA, disciplinary authority will decide. Now, disciplinary authority on this point, disciplinary authority also doesn't decide on this point. He knows, my lord, with great respect, he knows that how can I go ahead and say that no, it doesn't lapses. Once it lapses, that means you cannot go further beyond that. This is a major point. If on this point, if the court is satisfied here, you can't go ahead, end of the matter, my lord. Now, if your lordship finds, no, we have to go further. My learned friend said, no, that's not the end of the matter. Further, it can go ahead. Then again, second argument will be, these inspection reports are being placed before a board. This is number 2, board. Now, in that board, the board decides where inquiry officer, DA, all present in the board. Out of the 6 accounts, 3 accounts, they said, no, we have to close these 3 accounts. There is no lapses. Inquiry officer, DA was also a part of that board. But what they have done subsequently, after the closure, they go ahead and the DA issued a charge sheet against me. Who is a part of that board member? And in respect of all the 6 accounts. So this
let us see whether something can be done. The case is made out, clear-cut case is made out, then.
No, that's why I thought, my lord, I'll not trouble much of the factual part. My lord, only one paragraph, I think, then I will show the annexure. My lord, what statement I just made at paragraph 31, kindly be looked into it, my lord.
So the petitioner is presently serving as regional manager in the Assam Grameen Vikas Bank and
Yes.
posted at Nalbari.
Yes.
And
Now-
he is due for retirement on
30th of this month.
Now,
Now, presently, he's a chief manager, my lord.
all right.
Chief manager.
Now, some charge
I
memo,
see,
charge
my
sheet
lord,
has been.
I will know, my lord. There are other issues which has cropped up and your lordship will take this matter 2 hours, 3 hours like wasting. This point which I raise, and if there is an answer to this point, then I think that it will take some time. If there is no answer to this point, I think this can be closed.
And let us make an attempt.
Yes, I just make an attempt on this. So I thought that I will place this the first point before your lordship. That kindly see where I made a statement on this point, para 31. Para 31
Mr.
of
Das,
my-
just 2 minutes. Please take your seat, just 2 minutes.
Yes,
I'll take a stock of what is the
yes, yes,
synopsis of the case.
correct. You replace game. Nine. Supreme Court is amendable. Itu yang portfolio kok biasa nggak?
Yes.
My lord, before I just place it, I think just one judgment of the Supreme Court, which I said, I have been picked up and there was a committee and they decides, or the committee decide, and I have been picked up from there. And now that the committee has been picked up, no charges, nothing against them. So to that context, my lord, if your lordship looks into it, what happens? Suppose your lordship for a time being, your lordship don't go to staff accounting policy, how the Apex Court dealt with this particular issue, my lord. Kindly see para 18. Para 18. 2007 SCC 206.
Yes.
Kindly see para 18. After going through the report and para 18. After going through the report and finding recorded by division bench of the High Court, we are of the opinion that in fact the division bench correctly assessed the situation. Respondent alone was made a scapegoat, where a decision by all the three committees was unanimous decision by all these members participating in the negotiation. The price was finally accordingly. It is not the respondent alone who can be held responsible when the decision was taken by the committee. If the decision of the committee stinks, it cannot be said the respondent alone stinks. It will be arbitrary. If all fish stink, no pick one to pick one and say only it stinks is unfair in a matter of unanimous decision of the committee. In all the three charges, respondent has been found to be guilty for not assessing the reasonable price and report submitted by him, where the price indicated by owner of the land was 30 lakhs. Appointment of so as a valuer for land valuation was also for decision of respondent alone, and the exploration of soil and rocks, etc., given by the company was so and so was also not for the decision of respondent alone. Therefore, all the three charges which has been framed against the respondent as if he alone is responsible deal is not the correct approach. It is also not necessary that the landowner who has given the offer at one point of time at rupees 30 lakhs would stick to that. Instead, he has intimidated the appellant by her letter quoting the price so and so. Preliminary report submitted by the respondent directed commercial was after discussion of landowner at the cost of so and so. This cannot work as an estoppel against landowner. Maybe the landowner at point of time might have offered the land of so and so, but that report cannot operate as estoppel against the landowner, and she cannot jack up the price for the land. In fact, when the price negotiation committee also for written proposal from the landowner, she quoted so and so, so and so. So now what it says, my lord, the committee takes a decision. You have picked up one of the member from that committee and he has made a scapegoat and you are charging against him. This is
Where is the charge sheet? Where is the charge sheet?
Yes. My lord, charge sheet you will find at 41. 41. I thought I will place the judgment first, my lord,
Yes.
on this point. 41, my lord. These are article of charges in respect of these 6 accounts. My lord will kindly first account Gargi Associate, second is IR Associates, third, fourth, my lord, next page 42 kindly see. Now, out of these 3 accounts, I'll tell your lordship in very brief. My lord, 3 first at page 41, partially it is proved. So far as the 3 accounts at page 41. So far as page 42 is concerned, it is not being proved. It is not proved. So only what I argue before your lordship is that 41, a charge sheet has been issued by them.
What about the others in 42?
42, that's not
So has the
proved.
ruling
No,
made?
these are not proved. These
Not
are not
proved.
proved.
So only 3 accounts.
Yes, partially it is proved.
It is
Partially.
partially proved that
Partially it
the
is
other allegations are not established.
No, partially it was proved, not established. Now, there was an inquiry officer, there was a presenting officer, evidence was adduced, and ultimately there was an inquiry report. On the basis of the inquiry report, kindly see, my lord.
Yes, page number.
Yes, I'll just, inquiry report starts from page number 88. Page 88 is the inquiry report. These are the inquiry report, lengthy inquiry report, all the statement, how examined, how it has been done. Kindly turn to page 99. Kindly turn to page 99. My lord, this is the crust of the first argument which I made. Page 99, if your lordship goes down at the last bottom, after that bottom paragraph, thereafter, regarding, my lord, your lordship got a last, bottom last, there before that, regarding CSO submission, CSO means charge sheet officer, submission of branch inspection report and drawing of reference to the staff accountability policy, PO left the consideration, PO means, my lord, presenting officer, left the consideration of the same to the EO, inquiry officer. Inquiry officer, after perusal of the referred document, deem it necessary fit to refer the matter to DA for decision. This is what he says. Now, kindly see page 111, my lord. Then I'll make it very short. See 111. What argument we made before the bank? See page 111. What we said. 111, first paragraph. Page 111.
Yes.
As per D333, defense exhibit, a board note was moved by HOD personnel and general manager of the bank and placed by the honorable chairman. While board note 133/2021 in the board meeting dated 7/8/2021, in which it was clearly stated as follows: bank's internal inspection and audit team has conducted many inspections. However, no lapses has been highlighted in this regard. Management audit by the sponsor bank and NABARD annual inspection team has also not given any comments regarding lapses. Director also observed that these are very old cases and so many inspections have been conducted during this period. So now there is no point for fixing staff accountability at this stage. Therefore, board has decided to close the staff accountability in respect of the above account. As the board has already taken a decision, there is no point of framing a charge against me, which will be an arbitrary in nature. Ironically, in this particular case, General Manager Manoj Kumar Das, who has moved the note in the inquiry office and chairman, who has placed the note in the disciplinary authority, a settled matter in the board cannot be basis of charge, and therefore charges are not tenable. This is the basic, and that's what my lord, at page 99, which I pointed out before your lordship at 99, my lord. What is said that PO and CO and the USN.
What is this that you're reading, page 111? This is a part of
This inquiry, my inquiry report, my lord. Entire inquiry report, it starts from 88. It starts the inquiry, all reports here. And what was my stand which has been taken, that has been reflected. And ultimately, conclusion is page 112, my lord. 112. 112. Considering, last paragraph, considering the oral and documentary evidence record, respective contention of the management defense, analysis of facts brought into the light during the proceeding, a written brief by CSO and PO, and appreciation of evidence said above, I have come to the conclusion that charges level against the CSO White Bank dated so-and-so, and addendum White reference dated so in respect of Gargi Associate, IR Associate, constituting a partially proved. In respect of Progressive Motor, so-and-so are not proved. That's why I have shown my law, page 41, 42. There were 6 accounts. Out of the 6 accounts, page 41, 3 has been partially proved, and 42, page 42, 3 has not been proved. So that's what, but the EO never, my lord, doesn't discuss of the staff accountability policy. He sends it to the DO, and how the departmental authority, this disciplinary authority has issued, he also doesn't discuss about that. Kindly see at page 122. That's our impugn, my lord, which we have annexed at. Page 122. See, my lord, that is Chairman and Disciplinary Authority. A departmental inquiry was held with charges framed against you in the bank letter of charge dated so-and-so. Further addendum dated observing the principle of natural justice. Reasonable opportunity were given to you or this said inquiry for taking proper defense. You also participate in inquiry. I have carefully perused the records of the inquiry, day-to-day proceeding, evidence adduced, brief of both sides, finding of the inquiry officer and your submission thereon. I concur with the finding of the inquiry officer and satisfied with the evidence recorded at the inquiry and have come to the conclusion charges level against you have been proved and established beyond doubt. After considering the facts and circumstances of the case, gravity of the proved misconduct and your past record, I impose upon you the under-noted major penalty regulation 39.1b of the Assam Gramin Vikas so-and-so, reduction of basic pay of so-and-so. Consequently, his basic pay so-and-so plus stagnation in the month of January 2000 shall come down to so-and-so plus so-and-so. So this is what, my lord, a penalty has been imposed. Major penalty, my lord, my reduction in the basic pay. And my lord will kindly see, when this order was passed, the disciplinary authority doesn't make any comment on the inquiry which was sent to him regarding the staff accountability policy.
Just a minute, just a minute. So, out of this order of penalty,
yes,
one part of it is today's stayed. Debarring you from appearing in promotional interview, that is gone.
Yes.
That is not live today. Nothing can be, no release
Yes.
can be granted.
No, right.
in respect of
Only
that.
they allowed.
Only thing is the reduction of pay of one stage.
So what, this can be stayed, my lord. This can be stayed and ultimately, my lord, I retire. This can be stayed and can be heard. Let it be stayed. This order. This order can be stayed. And kindly see, my lord, at page 99, staff accountability policy, the EO sends it DA. DA doesn't give a reply. Doesn't give any reply. Kindly see where is that reply while deciding. Kindly see page 99. An inspection report, 2 inspection report. And my lord, as per the judgment of the Supreme Court, can I be, I'm a scapegoat? All committees member were there. You don't pick up, you pick up me.
You are a part of the 6-member committee.
Yeah, no, not. There were some committee members. 7, 8 committee members were there. Out of that, I was a part of it.
So no individual role has been ascribed to you.
So I have been picked up. What about others? That's what the Supreme Court is saying, my lord. You cannot make him a scapegoat. And my lord, what inspection has taken by the bank. 2 inspection reports were placed. No lapses. No lapses were found. Where is the question of again reopening of this particular charge sheet issuing to me? This is what, and there is no answer by the DA in respect of staff accountability policy.
Where is the staff accountability policy?
Yes, I have to take the order. Staff accountability policy. I'll just give it, my lord. 2021 10.2b. What was it? Just for a moment, my lord, just. Hmm? What was 10.2? Let's see that page. Where is the earlier 10.2? 10.2 कहाँ गया? One page is just missing, my lord. There's 10.2B. 10.2B. No, I forgot. Where is that staff accounting policy 2021? I'm extremely sorry for just your lordship has to wait. I find it. Where is that 10.2B? What type of papers you? What you'll see? This paper is missing. Where is that 10.2? AB. You don't have papers, I have got only one. Kindly see 10.2A, my lord. 10.2B and 10.2. See paper. Where is that thing? Data first. That's a staff accounting policy. Lordship got it, my lord?
Yes.
Now kindly see 10.2A-B. 10.2A first. No accounting will be fixed for any lapse which has not been pointed out in the two consecutive successive inspection report. However, in accounts where fraud has been reported, investigation will invariably be carried out irrespective amount to find the cause of fraud and involvement fault of any staff. In case any irregularity is attributed to any officials, the accountability will be examined staff accounting committee. Now this is important. 10.2B. Further, in case of investigation conducted subsequent to two regular inspection, after sanctioned disbursement of credit facilities, no fresh pre-sanctioned lapses other than those pointed out through regular inspection, reports be considered for fixing of account unless there is element of fraud, malafide, without the following stipulation. If the fraud has been perpetrated by the borrower on the bank, in the clause of two successive inspection report shall continue. In case of malafide action of collusion of staff with the borrower or fraud is perpetrated on bank by the staff members, then the time line shall not be applicable. If a fraud is perpetrated committed by any staff member, stern action will be taken. So what it says, my lord, lapses except fraud. It is not a case of fraud. So once two inspection report, 10.2B makes it very, that is why my lord.
Where are the two inspection reports?
Two inspection report, Amalo 9. Huh? It is not with us inspection report, my lord. That's inspection report, they have to.
From where does one find that two inspection reports?
I'm sorry, my lord.
From where does one find that two inspection reports were available?
Yes.
In respect of these transactions?
Yes.
You are saying two inspections were
Yes.
done and reports submitted.
No, because from the basis of the order at page 99, it appears 99 inspection reports. There will be two inspection reports. Kindly see 99 regarding last paragraph. Top regarding CSO submission of branch inspection reports and drawing of reference to the staff accounting policy. PO left the consideration of the same to EO. EO, after perusal of referred document, deemed it necessary fit to refer them to DA for decision. The inspection reports were there before them when the inspection took place. So this inspection will be with them, and they said, "No, I will not take a decision. Let it be the DA." DA, it sends it, no decision, DA. I have seen the impugn order, my lord. So my argument, first argument will be, once a committee has been set up, I cannot be made a scapegoat. So all this, my lord, leveling charges against me, it goes. Second, my lord, regarding about staff accounting policy. Once, my lord, the policy, these inspection reports are there before them, no lapses were found, there is no question of initiation of any charge sheet against me. Further, it is closed. And this is what fortifies by page 99. And DA doesn't pass any judgment on this issue.
And you have also alleged violation of principles of natural justice.
While charge sheet was issued, list of documents and this was not, I asked for, that was not provided. Inspection, this was not provided, my lord. This is, my lord.
Can you show it from the record that you had asked for these things?
Yes, yes. I made a statement also here, my lord. Paragraph 16 kindly be seen, my lord.
Yes.
Documents code of silent. Paragraph 16. 16. 16.
Yes.
That the proceeding held on 18/1/2023 to presenting or examine one witness as MW1 and exhibit certain more documents never shown before the petitioner, but included in ME10, that is beyond the agreed document. It was categorically recorded by inquiry officer in the proceeding held 13/1/2023 that no other documents would be accepted except the ones provided in the ME10, which included many documents which were never furnished or shown earlier to the petitioner, even during his visit for inspection of document. To mention a few, the said documents are included as ME exhibits 12, 14, 16, 17, 18, 21. Apart from some others related to other charges relating to other three accounts, which has been held to be not established. However, as will be evident from the inquiry report, the said documents have been relied upon by inquiry officer towards arriving at the finding charges relating to the three accounts are partially established. In this connection, specific reference may be made to exhibit 14 and 18.
And what is the reply in the affidavit?
Yes, kindly see, my lord, reply. They have filed an affidavit in opposition in respect of paragraph 16. My lord will find at page 1, paragraph 177, paragraph 15. That is a statement, save and except which a matter of record, allegation, ever on contrary are disputed and denied, same as set on seriatim and deny specific as per respondent while denying the statement, paragraph 16. Answering deponent begs to submit all documents as per ME10 were produced and or shown to petition on the first day of inquiry as on 13/1/2023. That is on day of preliminary hearing for verification of the same. On that day itself, presenting officer made a prayer to allow to add or delete any document related to the case in subsequent days of inquiry, and the same was granted as reflect the minutes of proceeding held on 13/1/2023. They have denied.
So all these loan accounts have turned NPA.
Yes.
All of them have turned NPA.
Third MPA on different dates. I didn't want to trouble. I thought that there is a point 6.1. It says that NPA, suppose it gets NPA prior to 2 years, preceding 2 years, whatever you have to do prior to 2 years preceding, you have to do it. So, my lord, we kindly see 6.1. 6.1. The code for 6.1. what we are saying here, kindly sign 6.1. Six point one, yes. Page 88. 6.1 बोली था से point 6.1. If your lordship page 41, I'll just give the date. Page 41 kindly be looked into it, my 41. This is our noting we have noted down. 6.1 million appointed us. The NP whole argument. My page 41, kindly see account number 1. That is sanction is 2010. My lord will kindly note down as per our the instruction. NPA is 29/5/2015. This is number 1. Number 2 account, this NPA is 26/2/2017. And third is 39/2012 NPA. So now my lord will kindly see at page 74. So now charge sheet is 2022, my lord. Lordship got it, my lord?
One second.
My lord will not see 42 page because 42 is not proved.
So the petitioner was the recommending authority in respect of all the first three loan credit disbursements. Thereafter, there are internal committees which had verified these proposals
Yes.
and sanctioned it.
Yes.
Only thereafter the loan was disbursed.
Yes, right.
So he is the recommending authority.
But there is a committee which looks into it. They have to look into all the documents. Inspection was done also. No lapses was found. Either that committee
Inspection
or-
with these organizations.
I'm sorry, ma'am.
The borrowers.
Yes. But see, my central vigilance, they say the sponsor bank is Punjab National Bank. The CV is here. The central vigilance is same as like Assam Gramin Vikas Bank. The officer, CV, central vigilance. Because there are stakeholders. All this bank has got a stakeholder. I think 51%, I noted down. I'll just give a note. 15% is the, I think, union, and some percentage is Punjab National Bank, my sponsor bank. 35, I think. 35, 15, and 51. No? Now kindly see 74, my lord, for a moment. 74. 6.1. Lordship got it?
Yes.
An account which was operated satisfactorily for a period of 3 years or more from the date of original sanction, enhancements and no irregularity lapses in regard to appraisal, sanction, documentation, compliance with terms and conditions of sanction, post-sanction follow-up have been pointed out in the concurrent audit, surprise inspection, RBI inspection, report RBI inspection, RO visits, any other inspection during the said period, and in 2 RBI inspection reports following disbursement, examination of the accountability will be restricted to the period in which the irregularities occurred ordinarily 2 years preceding date on which the account slipped to NPA. This will not be applicable in case of fraud or where mala fide intention is observed. Ordinarily, my lord, it is NPA preceding 2 years, so there is no question. That's the end of the matter. But that is not applicable in respect of fraud or mala fide where mala fide takes place. So this 6.1, my lord, again, there is a last point which I thought placing before your lordship. 2 points is very important for determination. Is the first
This
2
is
points.
6.1 of what?
6.1.
6.1 is of what? What is?
My lord, there is a proceeding of the departmental inquiry at page 68 and 69, my lord. 70, I'm sorry, my lord, this is 72 is the proceeding of departmental inquiry. Proceedings at page 72.
Now, this disciplinary departmental proceedings are conducted as per some rules of the bank, some standing instructions, something must be there.
Yes,
What is it?
yes. These are, my lord, disciplinary court coordinator. I'll just show my lord.
And on what ground
Yes.
major penalty can be imposed?
Yes, only this, my lord. Page command, sir. Yes, I'll just give that, my lord. We have that. 39. This is under Assam Gramin Vikas Bank Office and Employee Service Regulation 2010. I'll hand over that, my lord. Assam Gramin Vikas Bank Officers and Employees Service Regulation 2010 and Assam Gramin Vikas Bank Officer and Employees Service Amendment Regulation 2018. That is under 39, my lord, penalties. This
What
is under
does it say?
39.
Penalty can be imposed when?
Yes. I'll just give a copy. I'm having. This is- What is the photo? Your lordship can take this.
No, you have given a copy.
No, I'll just give a copy. I know what you mean, no?
So where is the finding as regards clause 39 that the petitioner is guilty of one of these?
The finding, page 122.
No, that is a finding by the disciplinary.
They have not, my lord, this has been
Where is the
placed.
finding by the inquiry officer?
No, there is nothing. He's just places before the DA. He doesn't take a decision of his own. He's only conclusion and sends it to DA. And DA, my lord, there is no application of mine by DA. DA, there is no application. Kindly see where is that, my lord? No finding, nothing. He's only sends it at page 111. 111 he sends to DA. Please decide it. DA doesn't decide. DA decides his own is that on the basis of EO, I am satisfied. There is no independent mind. That's not 39, my lord. There's nothing on that. Why major penalty? Why 39? Nothing.
Yes.
So I think, my lord, this is a case where, my lord, I'll submit humbly before your lordship, it's a case of interference by this court, my lord. There is no finding of EO while deciding it. Sends to DA. DA also doesn't give any finding. Doesn't apply his own mind. Kindly see how they escape of staff accounting policy. He keeps quiet on that. That's my submission to your lordship.
May it please your lordship. Your lordship, in respect of the submission by my latest senior friend that they haven't been given ample opportunity. Ample
No,
opportunity was
we'll
given.
go to those things later.
Lordship.
See, this proceeding is bound by your whatever rules you have, is it not?
Yes, service regulations.
Yes, Assam Gramin Vikas Bank Officers and Employees Service Regulation. So service regulation number 39, regulation 39 says that these are the grounds on which a penalty can be imposed on an officer. Correct.
Lordship.
Now, first of all, please point it out to the court. Where is the finding recorded that the petitioner is guilty of any of this misconducts or whatever, negligence, inefficiency, where is the finding?
Lordship, in this regard, your lordship may kindly see page number 94.
94.
Your lordship, this is with regard to the account of Gargi and Associates, your lordship.
Mr. Chetia, where is the finding? If
Lordship,
it is there, it's show it. If it is not there, you can't maneuver here in this court.
Lordship,
That's not
I
going to
understand.
happen.
Lordship, here the inquiry officer has categorically stated.
Where is it?
Your lordship, below there is the charge. Above that, hence the charge is partially approved, and above that, from the analysis of the charge, considering the documents and witnesses, both sides argument, the POs and COSO's brief, and applying my mind, I am of the opinion that COSO, as one of the member of the recommending committee, did not verify the credentials of the borrowing company in recommending the loan proposal for sanction, your lordship.
So there is no finding that he is guilty of any of those.
That aspect is categorically is not there, but
That's the end of the matter.
this
That's the end of the
observations
matter.
are there, your lord. That is,
That's the end of the matter. And why only he should have verified, not other members of the committee?
your lordship, in respect of the other members, most of them have retired. That is why no proceeding was initiated. And with regard to two members, the Punjab National Bank is taking up proceedings here.
Sorry?
In respect of two of the members, they were of the Punjab National Bank, so they are conducting proceeding against them. The proceeding is going on.
No, but the most important thing is, if you want to impose a penalty, you have to come to a finding that the petitioner is guilty of one of the.
I understand. Categorically, that line is not.
Then if it is not
But,
there, somebody has come to office, somebody has not gone to office, somebody has opened this file, so impose penalty. That can't be the case.
But lordship, their charges were proved in partial manner in respect of the three matters, your lordship. I understand what your
These are
lordship
not
is saying.
charges, first of all.
Lordship,
These are article of allegation, statement of allegation.
lordship,
What is the charge?
lordship,
What is the charge against the petitioner?
lordship.
There is no charge. These are all allegations.
Allegations,
Allegations are not charged.
lordship, but the allegations with regard to the accounts are proved, your lordship, that he has, there was,
Allegation is that as a recommending authority, he did not recommend.
lord,
Okay, he did not recommend, so what is the problem? What is his charge? Where have you said that by not doing so, he has acted in a negligent manner or he has committed a misconduct within the meaning of the rules? Where is that charge?
that
You have to
is-
make that charge clear.
lordship, that clear, actually, lordship, these people are banking officers, so.
They have law
some,
officers also.
yes, your lordship.
All right, they are banking officers. But then,
The wordings might not be in absolute proper manner, but your lordship, that
this is a serious matter. You are imposing major penalty on someone.
lord,
It is not there, is not there. The matter is and matter ends there. And even on merits, what is this allegation? All these things were processed by a committee, and you suddenly pick up one person. You say that he did not do this, he did not do that, he did not verify the record. All right, he did not. So,
your lordship, those who can,
so if he is not verified, so
your lordship, later on, there might be some malified intention for not.
where is the allegation, Mr. Chetia?
Lordship, that I
You
understand.
show the allegation. You have not even alleged. There is no allegation of misconduct. There is no allegation of negligence. There is no allegation of malefice. No allegation of fraud. No allegation of collusion.
Yes.
Neither there is any allegation, nor any charge, nor any finding.
In that
Then
respect,
don't you
yes.
think it's time for the court to dictate the order?
I'll leave it to your
Huh?
lordship. I'll leave it to your lordship.
Supposing we leave it to you, what would you say?
I will be saying in favor of my client, your lordship.
Sorry?
Nothing.
Mr. Saiwala was here. Why has he left? Because of
No, lordship, there is some
The merit of
mention
the
is
case.
there in court number 10.
some?
one mention is there in court number 30.
Mention?
Yes, your lordship, we'll just mention it and come back. That was my instruction. Your lordship. Can we just, if your lordship permits?
Don't
Lordship, I'll.
Don't forget the basic courtesy.
Lordship.
You can't ask a
Lordship,
court to
that
wait
is-
because the council
that
has gone
I'm-
to mention in other court.
I'm being.
Have some sense of decency.
Lordship.
I'll record his name.
Lordship.
Take
And
down.
all the affidavit which they have filed, it is all based on knowledge, not on records. Affidavit filed by them. Affidavit in opposition, paragraph 1 to 36, all based on knowledge. Affidavits.
Heard Mr. D. Das Lanet, Senior Counsel, assisted by Miss
You, Sharma.
Sharma, and counsel appearing for the petitioner. Also, Mr. G. N. Sahiwala, Lanet, Senior Counsel, assisted by Mr. M. Chitya, and counsel appearing for the respondents. Full stop. The lead petitioner hearing is presently serving as the chief manager in the Assam Gramin Bank, Assam Gramin Vikas Bank, and is posted at the head office at Guwahati. And is presently posted at the head office in Guwahati. While he was serving as the senior manager of the bank and posted at the Nalbari branch. Nalbari branch. Is
Can
it?
I give the list of dates? Mike?
Yes, give it.
The list of events, what has happened. List. And short written argument which I prepared.
I'm dictating the judgment. No
Yes,
time for argument.
No, just a short. This is a list of events. Yes, I do.
When the charge sheet was submitted, he was working as senior manager in Nalbari branch. On 30/8/2022, a charge sheet was submitted. A charge sheet was served upon the petitioner containing as many as 6 articles of charges. Full stop. On 30/9/2022, the petitioner submitted his reply, thereby denying the allegations brought against him. However, not being satisfied with the reply submitted by the petitioner, the disciplinary authority of the bank had, that is the chairman. Chairman is the
chairman is
that is the chairman. The disciplinary authority, that is the chairman of the bank, had decided to hold an inquiry proceeding into the charges brought, into the allegations brought against the petitioner. Full stop. Consequently, an inquiry officer and presenting officer was appointed, and the inquiry proceeding was held. Full stop. On conclusion of the inquiry proceeding, the Mr. Sahiwala, you were absent in between briefings.
I'm similar.
See, there are 3 grounds.
Yes.
Which Mr. First of all, just hold for a minute. You see, there is no charge in this case. There is no charge. These are all statements of facts. You did not carry this, you did not carry that. A charge has to be that you have committed a misconduct because of your negligence, or you are a part of a fraud, or you are in collusion, or there is a malafide act. Therefore, you are liable to be punished. And these are the statements of imputation of the allegation. Mere fact that you did not recommend, you did not do this, that could be the particulars leading to the charge. But there is no charge at all here. You have to have a charge because of clause 39 of your regulation. Clause 39 says a major penalty can be invoked only if these conditions are satisfied.
Yes.
There is no allegation, no findings, no recording of satisfaction on that anywhere. Neither in the article, nor in the inquiry report, nor in the order of penalty. So therefore, first of all, this is in complete contravention of the scheme of your regulation. Secondly, these are matters where he has been a part of the committee, which is the recommending authority of the loans. There is no basis given as to why he has been singled out.
No,
Nothing.
others are also, my lord.
No, others may be, but they are not a part of your bank. They are not a part of your bank.
Punjab Bank is.
You have to ascribe a role to him. He may be a part of the committee, but what is his role? You have not ascribed that role anywhere. On a cursory glance, I have seen it is not there. What has been held by the inquiry officer is this has happened, that has happened, this record was there, that. But what is his role? And how does that role in the facts established show that he is guilty of a misconduct within the meaning of, there is no finding by anyone. The inquiry officer has merely made a catalogue of facts and forwarded it to the disciplinary authority, and he has imposed the punishment. So this is a completely perfunctory and mechanical exercise. You can't impose a major penalty on someone on those grounds. What remains then after this? What remains? At least the charge should have been very clear. If a person is not served clear charge sheet, how can he be penalized?
Anyway.
You see, I am giving an example. Somebody not filing a proper document before the court.
Yes.
In a given circumstance, that could amount to a misconduct by the lawyer. In another circumstance, it may not be. So merely the fact that some proper document has not been filed, that cannot lead to a penalty. Unless one says that because of your conduct, this is a misconduct committed by you. Or you have indulged in XYZ kind of conduct, which is prohibited under the rules, some rule. Unless that is done, no question of penalty.
No.
No question of penalty. Because something happening here, something happening there, that is all right. You may like it, you may not like it, somebody may find it okay, somebody may not. But there are sets of rules, and these rules are framed to protect the rights of the employees under Article 16. I am going to hold that by not observing these stages, it has led to infraction of the petitioner's right under Article 14, and as well as principles of natural justice. Do you have anything to add here?
No.
All right. I have recorded your presence.
Yes.
What is the last? The inquiry officer had submitted report dated
21/1/2023 at page 88. Page 88.
report dated 21/1/2023 and forwarded the same to the disciplinary authority. That is the chairman of the bank, first up. On receipt of the inquiry report dated 21/1, is it 21/1? 21/1/2023, the order of penalty dated 01/02/2023, imposing the following major penalty, imposing a major penalty upon the petitioner, was imposed by the disciplinary authority. Aggrieved thereby, the present writ petition has been filed. Full stop. By referring to the article of charges, Mr. Das Lanet, senior counsel for the petitioner, submits that the materials on record clearly go to show that the credit facilities were extended to all the 6 entities after thorough verification of the credentials by the designated committees, and also after carrying out inspection of the units by the authorized team. Full stop. Mr. Das submits that his client was merely a member of the recommending committee. Full stop. Since no specific role has been ascribed to the petitioner and considering the fact that the credentials of these firms have been verified by successive committees and the loan disbursement was processed on the basis of report of the inspecting team. There was no justifiable ground to initiate the inquiry departmental proceeding against the petitioner. Full stop. By relying upon the decision of the Supreme Court rendered in the case of Bongaigaon Refinery and Petrochemicals Limited and others, reported in Girish Chandra Sharma versus Girish Chandra Sharma, reported in 2007, bracket close 7 SCC 206. Mr. Das submits that since the petitioner was a part of a committee, hence he could not have been singled out and made a scapegoat in the entire process when there is no specific role ascribed to the petitioner in his individual capacity. Full stop. By referring to the provisions of Rule 10.2 bracket small b of the AGVB Staff Accountability Policy 2021, Mr. Das, known as Senior Counsel for the writ petitioner, has further argued that after 2 regular inspections were conducted pertaining to the disbursement of the loans, there was no scope for the authorities to initiate a departmental proceeding into the said transactions, since the same was barred under the aforementioned provision of the accountability policy of 2021. Notwithstanding the bar imposed by the policy of the bank, without there being any justifiable ground for departing from the same, the authorities have chosen to initiate the departmental inquiry in this case only to make the petitioner a scapegoat of a bad loan transaction. Full stop. Contending that there is neither any allegation nor any material available in record to indicate fraud, collusion or any mala fide action in respect of any of the team members of the committee. It was not permissible for the authorities to initiate a departmental proceeding in respect of loan transactions which had taken place more than 3 years.
Yes.
More than 3 years prior to the
2 years.
more than 2 years
Yes.
prior to the submission of the charge sheet. Full stop. Mr. Das has also invited the attention of this court to the findings and observations made in the inquiry report to submit that with regard to the branch inspection reports, the inquiry officer had also refrained from recording any finding and has left the matter to the discretion of the disciplinary authority, who had also not dealt with the case in any manner.
Yes.
As such, the respondents have completely failed to explain and completely failed to discharge their obligation of satisfying the mandate of Rule 10(2)(b) of the policy of 2021. Full stop. Finally, Mr. Das has placed reliance on clause 6.2 of the what is this?
Case 74. 74 proceedings of the minor quiz starts from page 72. Page 72.
6.2 of the
6.1.
6.1 of the proceedings of departmental inquiry. And finally, Mr. Das has also relied upon the observations made in clause 6.1 of the proceedings of departmental inquiry to submit that the materials available on record were clearly inadequate so as to go for a waiver of the mandate of clause 2.10.2 bracket B of the policy. Full stop. Mr. Sahiwala, that is senior counsel for the bank, on the other hand, has argued that the other team members of the recommending committee belong to some other bank, and as per instructions received by him, inquiry proceeding was conducted against the said officials as well.
Going on.
However, since they belong to another bank, the outcome of the said process is not known to him. Full stop. As regards the finding of the inquiry officer is concerned, Mr. Sahiwala submits that 3 out of the 6 charges brought against the petitioner have been found to be partially proved, and therefore the taking note of the findings and conclusions recorded by the inquiry officer, the disciplinary authority has rightly imposed the penalty upon the petitioner. First up, contending that there is no perversity in the findings recorded in the inquiry report. Mr. Sahiwala has urged that in a matter of this nature, the writ court may not interfere in exercise of jurisdiction under Article 226 of the Constitution, since the punishment is not disproportionate to the allegations brought against him. First up, I have considered the submissions advanced at the bar and have also gone through the materials available on record. At the very outset, now, considering the nature of controversy involved in this proceeding, this court is of the opinion that it would be necessary to reproduce the articles of charges contained in the charge sheet dated 38/2022. Full stop. Therefore, the relevant part of the charge sheet is reproduced herein below for ready reference. At page 41 and 42. Next paragraph. As has been noted herein below, the inquiry officer had found that the charges brought against the petitioner, that the first 3 charges brought against the petitioner, namely those pertaining to the accounts of Messrs. Number one, Messrs. Gargi and Associate Private Limited, number 2, Messrs. IR Associates, and number 3, Messrs. Kaushika Trading Industries.
Tea industries.
Kaushika Tea Industries have been found to have been partially proved, whereas the remaining charges were found to have been not proved. Full stop. Based on the aforesaid inquiry report, the learned and the chairman of the bank, who is the disciplinary authority, had imposed the following penalty upon the petitioner, which is reproduced herein below. Page 122, double tick to double tick. Full stop. Since Mr. Das has argued that his client is due for retirement on attaining the age of superannuation with effect from 30th of November 2023. Hence, a part of the penalty pertaining to his debarment from appearing in promotional interview oblique test for a period of 1 year would not be relevant. at
Well,
this
he is
point.
allowed, my lord.
Huh?
He has been allowed to appear. He was allowed to, but nothing happened. I was allowed, but they
Would
were.
not be relevant at this
Yes.
point of time. Full stop. Although Mr. Shaivala has argued that the petitioner was allowed to participate in such interview, this court does not deem it necessary to enter into that aspect of the matter in view of the categorical submission made by Mr. Das that the said aspect of the matter has lost its relevance at this point of time. Full stop. Insofar as the other part of the major penalty pertaining to reduction of basic pay, what is to be noted here in that under the Assam Gramin Vikas Bank officers and employees service regulations, 2010 bracket of hereinafter referred to as regulations of 2010. Penalties can be imposed upon an officer of the bank as per regulation 39, which is quoted herein below. Double-tick, regulation 39. Huh? Yes, sir. From the scheme of the regulation, it is clear that unless the conditions as specified in regulation 39 is met, the question of imposing any penalty, be it minor penalty or major penalty, would not arise. Full stop. From a careful reading of the article of charge, this court finds that although there are statements of allegations contained therein, yet there was no charge within the meaning of regulation 39, which was included in the charge sheet at all. Full stop. Not only that, there is no finding recorded by the inquiry officer that the petitioner is guilty of violation of any of the regulations, or has acted in a negligent manner, or has shown inefficiency, or is found guilty of any other form of misconduct, including breach of discipline, etc. Full stop. All that the article of charges indicates is certain alleged lapses on the part of the petitioner in his failure to verify certain documents and oblique records as the recommending authority. However, what is to be noted here in that at no point of time was the petitioner individually processing the loan, as he was all along a part of the team of recommending authority which had processed the proposals. Full stop. That apart, it is also evident from the materials on record that there are other organs of the bank which were involved in processing the loan, which included the inspection team. Full stop. There is nothing on record to show as to in what manner the role of those officials had an impact in disbursement of the loan. Full stop. Next, coming to the other argument advanced by Mr. Das by relying on clause 10.2 bracket B of the policy of 2021. It would be pertinent herein to extract the relevant part of the policy herein below. Policy relevant part of the policy, that is clause 10.2 B herein below. It will extract 10.2 bracket B. First up. A plain reading of clause 10.2 bracket B goes to show that the said policy clearly puts in place a timeline beyond which the bank would be debarred from inquiring into any lapses regarding sanction of loan and or pre-sanction lapses. The only exception provided under the aforesaid clause is pertaining to cases of fraud or collusion involving the bank employees or staff. First up, as noted here and above, there is no allegation of fraud and collusion against the petitioner in this case. If that be so, it is apparent on the face of the record that the departmental proceeding was clearly time-barred, even under the AGVB staff accountability policy 2021, which was obviously binding on the bank. First up. Therefore, by acting in violation of the policy of 2021, the bank has not only the disciplinary authority has not only acted in an illegal and unfair manner, but by imposing the major penalty upon the petitioner on the basis of the inquiry report dated 21/1/2023.
Yes.
Has also violated the fundamental rights of the petitioner guaranteed under Articles 14 and 16 of the Constitution of India. First up, this is further apparent from the fact that when the petitioner has been served with a major penalty, as indicated above, there is no specific charge brought against him at all within the meaning of the regulations of 2010 as elaborated herein above. First up, the petitioner has also taken the plea of principles of violation of principles of natural justice due to the non-furnishing of relevant documents along with the charge sheet. First up, however, such allegation has been denied and disputed by the bank. Be that as it may, for the reasons indicated herein above, this court is left with the unhesitant conclusion. This court is of the unhesitant conclusion that the departmental proceeding was conducted against the petitioner. The departmental proceeding conducted against the petitioner was not only in violation of the specific violation of clause 10.2 bracket B of the policy of 2021, but the same was also held in utter violation of principles of natural justice, as well as the provisions of the regulations of 2010, thus causing serious prejudice to the interest of the petitioner. Full stop. There was no justifiable ground for the petitioners, for the disciplinary authority to impose the major penalty upon the petitioner in the manner indicated herein above. In the result, this writ petition succeeds and is hereby allowed. The order of penalty dated so-and-so is hereby set aside. What else?
Only one prayer. My promotion, which my lord Dev denied, that will be kept open in separate proceeding. I'll be given a liberty. So a promotion is concerned because I didn't get because of all this. My that will be kept open if advised by my client, my lord. That's only my prayer, my lord.
No, well, that actually we have submitted the original records also, because he was allowed to, irrespective of this, my lord, he was allowed to participate in the.
But my participation, I have said
And
how you have
participation, my lord, there
selected.
is a report, my lord.
That's my what my lord. If my client advised, so advised.
No, then you have taken this plea here only.
Yes.
No, I have taken. I didn't want to pursue this issue, my lord. Only on the ground because of time
that can't be-
factor.
Mr. Das, that can't be done. Either you have to assert it here or it's over. It can't be that I will press this much, give me this relief, later on I'll take
No, I
that.
don't want to trouble your lordship. It's only
No,
keeping
it's
open.
professional trouble.
Keeping open that if advised my client, so for a promotional concern, I'm not troubling. He is going to superannuate on
No,
30th.
you said, I've recorded the submission that issue is no longer
No
relevant.
relevance, my lord, at the present instance.
Because he was allowed to, only my lord, observed that he will not be allowed to participate. But he has already allowed to participate.
No, I participated.
My lord, so
Manner.
that punishment has already been my lord done.
I didn't because I wanted how.
Before parting with the record, it is made clear that since the decision of the authority is not to promote the petitioner after his participation in the process is not a subject matter of this writ petition, this court does not express any opinion on the said aspect of the matter and leaves the parties at liberty to avail appropriate legal
I'm
remedy.
But the original records are there, but these were the-
Original record be returned.
Replay.
I either
Dispose of.
The record is, they're not able to trace out the record. And today itself, Lordship, I talked with the concerned ADC, Lordship. He told that one team was, they constituted team for trace out this record, Lordship. And therefore kindly accommodate some time, Lordship.
So how much time?
Lordship, 2 weeks time, Lordship.
Ms. P. Bhattacharya, learned counsel for the writ petitioner, is present and has invited the attention of this court to the order dated 21/9/2023, by means of which the learned government advocate Assam was asked to obtain necessary instructions and also to produce the records. Today, when the matter is called up for hearing, Mr. J.K. Goswami, learned additional senior government advocate Assam, has produced a copy of the communication dated 12/10/2023, issued by the additional deputy commissioner revenue, the bracket revenue, bracket close Golaghat, to submit that the records could not be traced out, but a team of officials have been deputed to trace out the record. As such, hearing of this matter be adjourned for 3 weeks. Mr. S.P. Sharma, learned counsel, is present on behalf of
4 and 5.
respondent numbers 4 and 5. I'm taking note of the prayer made by Mr. Goswami, and considering the importance of the records in this case, this matter is directed to be listed again in the first week of January as a fixed item for hearing as per roster.
His part had.
January it will go. January 2nd week.
As part had Lordship. Part.
It will come up.
Already
First week or second week?
Second week, Lordship.
Second week of January for hearing.
Lordship.
Item 8.
May I please your lordship, letter may be passed over for the time being.
No. Why? What is this matter?
My lord,
2002
the
cases.
senior is in lax in another court.
You argue then. Who is for the respondent? All right. I'm disposing it of directing them to consider your case for promotion as per the rules. Heard Miss
And Gupta.
N. Gupta, learned counsel, appearing for the writ petitioner. None has appeared for the respondents, although the name of the counsel have been shown in the cause list. Full stop. The writ petitioner hearing was appointed as a master role worker in the office of executive engineer, PWD, Lakhimpur on 01/10/1990. After serving for several years in the grade 4 post, the petitioner claims to have become eligible for promotion to the post of LD assistant, which is a grade 4 post, which is a grade 3 post. Yes, what do you have to say?
My lord, we have filed our affidavit.
Hmm.
My lord,
We examine his claim, and if he is found eligible under the rules, consider him for promotion.
my lord, we have already stated that he is not eligible.
Why
He-
he is not eligible?
My lord, he is an HSLC pass, number one, and two contentions that the petitioner has raised is that the private respondents were given promotion, my lord. So, my lord, if you go by the list, there was never a gradation list of MR workers, my lord. When they were regularized, a list, my lord, was made. And accordingly, he was in serial number 203, whereas the other private respondents were in 5 and 6. We have stated in para 5 of the affidavit. So that's why they got promotion earlier and their education qualification. From the very beginning only, respondent number 5 was a graduate, BA pass, and 6, he was into my official thing, he was engaged. So, he was a good typist. That is why they got the promotion. Whereas
What is the qualification for grade 3 promotion? To grade
now, my lord, it is graduate, my lord.
But
And HS pass for section assistant, it is science, 12 science.
no, but have you not promoted any masteral worker to grade 3 who is not a graduate?
My lord, here, my lord, we can always examine, my lord. My lord may direct. But this is what is there in the contention of the affidavit. That is what I'm just trying to bring out before your lordship. Otherwise, my lord, it is always my lord may direct. We'll examine, my lord.
Okay, then you write, also heard Mr. Ardhar, Learned Standing Council, PWD, Assam, appearing for the respondent numbers. Respondent numbers 1 to 4. None is appeared for respondent numbers 5 and 6. That part will continue. Also, eligible to have been to be promoted to the post of LD assistant, which is a grade 3 post. Notwithstanding the same, the respondents have not considered his case for promotion. On the contrary, the private respondents numbers 5 and 6 who were junior to the petitioner had been promoted to the post of LD assistant. Mr. Dhar, Learned Departmental Council has invited the attention of this court to the counter affidavit filed by the respondent number 3 in this case to submit that the respondent numbers 5 and 6 were placed higher in the gradation list of
This masteral worker, my lord, after
masteral
regularization.
masteral workers after regularization of their service, and therefore the claim of the petitioner that they are junior to him is wholly unfounded. Full stop. Insofar as the other ground for denying promotion to the petitioner is concerned, Mr. Dhar submits that the petitioner is not a graduate and therefore he cannot be promoted to the post of LD assistant after the amendments of the rules carried out in the year.
My lord, rule 2013, my lord.
After the amendments of the rules, which according to Mr. Dhar took place in the year 2013. Full stop. The Learned Departmental Council could, however, not address this court on the point as to whether the petitioner was eligible for being considered for promotion prior to the amendment of rules, and if so, whether the amended qualification norms would at all be applicable to him if there were vacancies available at that time in the grade 3 category. Full stop. Situated thus, this court is of the opinion that the claim of the petitioner calls for a fresh consideration in the light of the observations made herein above. This writ petition is therefore disposed of by granting liberty to the petitioner to submit a fresh application, a fresh representation seeking promotion by furnishing the necessary particulars. If such representation is submitted by the petitioner within 6 weeks from today by enclosing a certified copy of this order, the same be considered on merit and disposed of by a reasoned order. With the above observation, this writ petition stands disposed of. What is the IA about this case? What is the miscase about?
Mine. GWS.
What is this matter? None appears for the petitioner on call. Mr. D. Dale and DK Dale and DK Day, is it? D. Dale and council is present for the respond number 4. The state council, the council for the respond number 1, 2, 3 are also absent. In view of the above, although this is a old pending matter, yet hearing of this case stands adjourned for 4 weeks so as to give the parties one more opportunity to appear and argue the matter.
Item 10.
May I please, Your Lordship, my lord?
Yes.
Here, the petitioner, he retired as district fishery development in charge, my lord. So he claimed the promotion, my lord. Yeah. That
your client is retired 10 years back. Now he wants promotion.
No, I filed petition, the writ petition I filed, my lord, earlier, and the department, the respondent were directed to consider my case, and they passed one speaking order, my lord, where I am agreement.
Page number? Page number?
Speaking order, it is at page 39, my lord. Here, my lord, can you see it? The grounds they have stated in number 1, can you see, my lord? There is no service rule for the fishery services at present, as the services matter of fishery officiary is governed by the Assam Fishery Services Equipment and Promotion Orders 1989. As per provision laid down thereon, the subdivisional fishery development officer is a promotional post from fisheries extension officer and allied cadre with 3 years services experience in the department and having minimum qualification BSc with postgraduate training in fisheries science in CIFRI and CIFE or any other equivalent training recognized by ICAR BF Science. The petitioner was promoted to the post of subdivisional fishery development officer in the year 1992 from the post of fisheries extension officer by notification number so and so dated 30/10/92 under regulation 4D of the APSC limitation and functions regulation 1951. Therefore, until and unless such promotion is regularized
with the recommendation of the APSC, there appears no scope for consideration of further promotion of such promotee to the next higher post. In the instant case, recommendation of the APSC for regulation of the promotion of the petitioner along with some others has been received in January 2009, and accordingly their promotion in the post of sub-divisional fishery development officer have been regularized in May 2013 by notification number so and so. Then number 2, man. As per service orders mentioned under 1 above, the district fishery development officer is a promotional post from the post of sub-divisional fishery development officer, and its cadre rank as per the said service order is only 18. But consequent upon upgradation of the post of district fishery development officer of the district of Dhubri, Kokrajhar, Shonitpur, Lakhimpur, Kamrup, Nagaon, Jorhat, Dibrugarh, Karbi Anglong, Kasar, and Karimganj to higher scale of pay 1835 to 4,825 by an order issued under notification number so and so dated 19/7/1993. It comes down to 12 and remaining 6 numbers of post district fishery development officer of the districts of Goalpara, Borpata, Nalbari, North Kasar Hills, Sibsagar, and Golaghat are redesigned as the additional district fishery development officer in the existing pay scale by an order issued under notification number 7. As a result of such bifurcation of the cadre of DFDO, it becomes anomalous for consideration of the promotion of SDFDOs, whether their promotion would be made to the upgraded post of district fishery development officer or to the post of additional DFDO, a non-existent post in the cadre in the service order mentioned above. On the other hand, it becomes difficult to allow to the sub-divisional fishery development officer to the post of DFDO by passing the intermediary post of additional district fishery development officer. In ROP 2010, the pay scales of the post of DFDO, additional DFDO, and SDFDO are shown as below. And district fishery development officer 12,000 to 40,000. Then additional district fishery development officer 8,000 to 35,000. Then sub-divisional fishery development officer 12,000 to 40,000. It is seen that the pay scale of lower post of auto is higher than the pay scale of the higher post. So there appears difficulty for promotion from the post of sub-divisional fishery development officer to the post of additional district fishery development officer due to pay anomaly. However, this anomaly has come to the notice of the government, and to ease with this situation, necessary steps for amalgamation of the post of additional district fishery development with the post of district fishery development officer in consultation with concerned departments have been taken up. And for the petitioner, Sir Habibur Rahman, figures at serial number 16 of the gradation list 2002 of the subdivisional fishery development officer. His promotion to the next higher post shall depend upon the suitability criteria procedure prescribed in the aforesaid service orders as and when the matter of promotion is completed. Order. The matter of promotion of fishery officer, including the petitioner of the rank of sub-divisional fishery development officer to the next higher rank, is under active consideration of the government. Despite sincere and constant efforts to clear up the anomaly in the fishery services and to provide promotion to the petitioner within the time set by the Honorable Guwahati High Court, would not be finalized due to those difficulties mentioned above, which is time taking. Hence, the matter of promotion of Sir Habibur Rahman, Sub-Divisional Fishery Development Officer, Sibsagar, is hereby disposed of. So because of time taking, my lord, and some difficulties, they could not consider my case. But subsequently, my lord, after my retirement, they have passed one promotion order, my lord. Where is it? Yes, it is at page 57, my lord.
As page 57, my lord. This is the notification dated 22nd April 2015, my lord. Without prejudice to their entire seniority and subject to reversion within notice and without assigning any reason thereof, the following sub-divisional fishery development officer are promoted to officials as district fishery development officer at the places shown against their names under Regulation 4D of Assam Public Service Commission Limitation and Functions Regulation 1951 in the scale of pay of rupees 12,000 to rupees 40,000, to get pay of rupees 5,900 against sanctioned post, sanctioned vacant post with effect from date of taking over charge. Here, 18 similarly situated persons, they were promoted, but here my juniors are also there.
order.
Oh. 9.
Yes. Sir, not consider, and if you want to reject, reject it. The High Court has just asked
that
to consider.
that promotion order, my lord, whoever is qualified, they have been considered. Here is a case, my lord, that the petitioner, my lord, page 61 of our affidavit rule we have annexed. Rule provides that for promotion to the district fishery development officer, one has to have a certain period of service in the feeder cadre and the minimum qualification of BSc with
Why didn't you pass that order? There is an order of the High Court. You consider it and pass an order.
That lordship, that we can do. One year training that petitioner doesn't have. In fact,
see, his right is only to be considered, not to be promoted.
Correct. And in fact, Lord, that for that training, petitioner was deputed at one point of time, but he could not complete that training. That training he doesn't have. And my lord, the persons who doesn't have the training, in fact,
That's correct. But where is the order of the High Court?
Order of the High Court is that to consider his representation and pass an order.
Where is that order?
Well, order is annexed in the writ petition. Kindly see at page 36.
That's right. So just consider it. That's all.
Lordship. Well, in fact, challenging the same on similar grounds, my lord. Some persons have challenged that particular 1 year training course on the ground that we have already rendered service for 25 years. In fact, for the promotion to the cadre of SDFDO, from the fishery development officer, there, that challenge has been negated by the Honorable Division Bench, and Division Bench has said that in view of these facts, the copy is with me, that the undisputed position is that the training is a mandatory requirement for fishery development officer to be considered for promotion to the next higher post of subdivisional fishery development officer. Here, similar training is also required for as a subdivisional fishery development officer be promoted to the next higher post. So that position remains. And in fact, honorable
that training is required under which provision?
Training is required under the draft rules.
I want to interrupt. Can you see at page 102, madam? 10, the last page.
Mr. Pukul, let him submit, then you make your reply.
Well, an affidavit has been filed by the respondent, kindly by Nirmal, additional affidavit in opposition by Nirmal Kanti Devnath.
No, forget who. We are asking you, where is the requirement to undergo a training?
Page 61.
For being promoted to the post of
yes, that relevant portion is rule is annexed, in the is possibly some. We filed the affidavit on 11/9/23, the last additional affidavit filed by one Nirmal Kanti Devnath. There, Lordship may kindly.
So who is this person, Nirmal Kanti Devnath?
He is the secretary, he is the joint secretary of the department.
Right.
But annexure 2, kindly take up annexure 2 in that affidavit, my lord. We have noted page number 55. May not be there, my lord, because this is the schedule 2 to the Assam Fishery Service that this prescribes the rules. Kindly come to 61. Page 61.
Page 61.
Page 61. This is the schedule. Lordship will find serial 7, district fishery development officer. District fishery development officer. The 100% promotion from the cadre of subdivisional fishery development officer with 5 years experience.
Just flag it where it is.
So this is a part of the schedule 2. Lordship will find serial number 7, district fishery development officer.
1 minute. This is a part of schedule of what?
Schedule 2 to the service order. That service order they are following. They don't have rule. Service order is there. That is what they are following. It starts at internal page that has been cut. Internal page 55. It is re-regenerated. Annexure Roman 2. It starts at schedule 2.
Yes.
Schedule 2. It continues to kindly come to that green flag.
Yes.
This is in respect of district fishery development officer. Below Lordship will find the others are there. District fishery development officer, column number 7, from the cadre of subdivisional fishery development officer with 5 years experience in the department, out of which 2 years in administrative post. Then column number 9, Lordship will find minimum qualification BSc with postgraduate training in fishery science in CIFRI CIFE or any other equivalent training recognized by the ICAR BFSC, Bachelor in Fishery Science. So that qualification is required.
Petitioner does not have that.
Petitioner was sent at one point of time. He was sent for the training. In fact, all the officers, they are from time to time sent for training. He could not, for 1 year training, he could not complete the training. In between, he left the training.
Where have you stated it?
In the affidavit.
The affidavit filed by Nirmal Kanti.
Yes, the same affidavit.
Which paragraph?
Same affidavit. Logic. Para 8, we have indicated that is as per the eligibility schedule 2, serial 7 we have said. Para 5.
Para 5.
The petitioner was accordingly deputed to undergo mandatory 1 year training at Inland Fisheries Training Center, Barakpur during 94-95. But the petitioner could not complete the said training due to a serious health issue and returned midway without completing the said training. We due intimation to the competent authority.
So he sought exemption.
He sought exemption. That was not considered. That was not considered.
So according to you, he does not fulfill the eligibility criteria.
At that point of time, my lord, no. And my lord, seeking relaxation as per rule 14, in fact, challenging that criteria, minimum qualification criteria, some persons who are seeking promotion to the cadre of SDFDO, subdivisional fishery development officer, the qualification criteria is same. They approach the honorable court. I have given the judgment, my lord, that their my lord, lordship has said that this is a writ petition 3546, Lord. The facts Lordship will find at internal page 7. And there, kindly, my lords, if kindly come to page 9, internal page 9.
Yes.
This matter has rather a checkered history, as we have been informed at the bar that at some point of time in the year 2017, the government itself had granted one-time exemption to similarly placed persons from training. All the same, later this exemption was withdrawn. The officers who are trained in fisheries, inasmuch as who are graduate in fisheries and who are the present respondent before this court, had also challenged the exemption granted to the petitioners. We had also been told that some of the petitioners had filed writ petitions which are pending before the learned single judge regarding promotion to the next higher post. In the present petition, however, the petitioners have challenged the relevant order which makes training a mandatory requirement for promotion on the ground that the mandatory requirement of training is not in fact unworkable. Mr. So-and-so, learned senior counsel for the petitioner, would argue that the petitioners have been working in the department for last more than 25 years on the post of fishery development officer and have not been considered for promotion even once in their long years of service. He would also argue that nobody can have a fundamental right for promotion, but once one does have a fundamental right for at least being considered for promotion, which is presently being denied to them. Learned counsel for another batch of employees who are trained in fisheries or are graduate in fisheries, on the other hand, would argue that they too have been working for more than 25 years or so, and the present exercise which is being undertaken by this state government is also for their first chance for promotion in last 25 years of service. And like the petitioners, they too have a right to be considered for promotion, particularly in the light of the admitted fact that it is only they who have all the requisite qualification for the said post, and the admitted position is that the petitioners do not fulfill the mandatory requirement of training. Admittedly, a fishery development officer who has not done his BSc in fishery or zoology must get 1 year's training in fisheries, and only then he would be qualified for promotion to the next higher post. It is also not the case of that fishery development officers in the department have not been sent for training. There have been cases where at least one person who was similarly situated, namely Pankaj Mohanto, who is much junior to the petitioners, was sent for training for 1 year. Therefore, the case of the government as well as the private respondents would be that it is not a case where opportunity was not given to the petitioners for training, but the fact of the matter is that opportunity was given but was not availed by the petitioners. At the same, even if this fact is to be considered, the fact of the matter is that this training was given in the year 2001, and after 2001, no such training was offered to the petitioners. At the same time, the petitioners have also not been able to show before this court that it was the duty of the government to send the petitioners for training, and that it was a part of in-service training. In view of these facts, the undisputed position is that training is a mandatory requirement of a fishery development officer to be considered for promotion to the next higher post of subdivisional fishery development officer. In the present exercise which is undertaken by the government, the petitioners are not being considered for the simple reason that they do not have the training and they are not graduates in fishery science. Since the rule itself makes training a mandatory for the petitioners, we cannot pass an order which is contrary to the rules. Therefore, at this stage, it is possible for this court to either—
It is not possible.
It is not possible for the court to either declare the requirement of mandatory training as unworkable as claimed by the petitioners, or to pass a direction to the state government to consider the case of the petitioners for promotion to the next higher post of subdivisional fishery development officer, irrespective of their training. Therefore, the present exercise must go on. So the promotion exercise, Lordship is allowed to go on. Here, one of the observations have been made. Having made the above determination, we also would like to make the following observations. It is undisputedly a case where the petitioners have put a long years of service in the department, and yet they have not been promoted to the next higher post of subdivisional fishery development officer. This court has also been informed that now the government has directed the petitioner to undergo 1 year's training in Kolkata. Out of the 11 petitioners who are before this court, 8 have already been selected to undergo the training. They must undergo the training in order to be eligible for promotion to the post of sub-divisional fishery development officer. For the remaining 3 persons, subject to their seniority and placement in the gradation list, the government may consider giving them promotion by creating supernumerary post or by giving them notional promotion, considering that they have put in long years of service and they are all at the verge of retirement. That is, they will reach the age of superannuation in less than 2 years from now. At so specific in respect of 3, because more less than 2 years was there in their service, that has been observed. However, this is purely the discretion of the government, as the power of relaxation is given to the government under clause 14 of the Assam Fishery Service Recruitment and Promotion Order 1989, which reads as under. Then 14 relaxation clause has been quoted, and the Honorable Court has held that the government shall consider all these aspects and take a decision in 8 weeks. So my respectful submission here is,
So what is the qualification of petitioner? He is a BSc in fishery.
He's a BSc. He is having the qualification of BSc, because that 1 year, if he's a BSc, minimum qualification of BSc with postgraduate training, that is required. If only BSc, then that 1 year training is required. In any case, 1 year training is required for him, because he was sent at one point of time, he was sent for the training. And that is, he doesn't have the, because he doesn't have the training, he was not considered for promotion. So my respectful submission is similar challenge that Honorable Court Lordship has seen, that the training is a mandatory thing, court has already held. Now, the petitioner, he retired in 31st of December 2013. So at this stage, his promotion only on the basis that he was allowed to hold the post of District Fishery Development Officer since 2005. He was holding the post as in charge. In charge is not if substantially to hold the post substantially, he doesn't have that qualification for promotion. Not that cannot be allowed. In charge, for the administrative regions, anybody can be allowed. His the projection he made in the writ petition, he said that I am eligible to be promoted, but this 1 year qualification he has not stated nowhere.
All right. That's all.
Yes, my pleasure. Here, my lord, kindly see, my lord, at page 102, last page, my lord.
One zero?
102. Last.
Yes.
Yes. Next. Here, this is the exemption from training, my lord. Isn't it? It is. I am directed to refer to your letter on the subject indicated above, and to say that the Governor of Assam, after due relaxation under para 14 of the Assam Fishery Services Recruitment and Promotion Orders 1989, is pleased to exempt Toyod Habibur Rahman as the FDO Shivsagar to undergo further training at Barakpur as required under Schedule 1 of the Assam Fishery Services Recruitment and Promotion Orders 1989 in consideration of his continual heart discomfort. So already the petitioner, he was exempted from training, my lord. So question of further training does not arise, my lord. To undergo further training does not arise, as because he had exempted from that, my lord.
So, Mr. Fukan, what is the order you are seeking?
My lord.
What order you want from the court?
Yes, I was in charge.
What is the order you want from this court today?
Promotion, my lord.
Promotion cannot be given by the court.
No, my lord.
Promotion the court cannot give. Court can only ask for consideration.
Yes. Here, my lord. The petitioner, he joined in the department in the year 1982 as fishery extension officer. Thereafter, he was promoted in the year nineteen
We
ninety.
ask the authorities to examine his representation and in the light of earlier order of the court and pass appropriate orders.
But that I will not object to.
Right. Take your seat. I'm asking them to
Done.
consider your representation and pass appropriate orders as may be justified. And there can be no direction to issue promotion. Perhaps you are not aware that kind of direction the court cannot give. Court can only ask them to consider your case. That's all.
Already, it is too late.
No,
my lord.
can't be. You will not get anything. This is not possible. It is over.
No, that day, my lord, as managed.
If they had considered your case and the consideration was found to be illegal, then the matter is different. They have given some reasons why your promotion could not be considered. There were anomalous situations.
No, those were the problem they have settled later on. Then they have issued the notification for promotion, my lord. So all are my similarly situated persons. And my son juniors of mine also, they are promoted.
But at that, we have to see what was the situation when you were in office. Subsequent promotion will not help you. On the day you retired, what was your claim?
Yes.
On that day, they said why they could not consider it despite the High Court order.
No, my lord, they have extracted my service as district fishery development officer, man.
Give it in that earlier stories. All right, order reserved. I'll pass the order.
My lord, can I give one suggestion?
Item 11. Please, Your Lordship.
Yes.
Your Lordship, here I was working as a storekeeper, Lordship.
Sorry?
I was working as a storekeeper in a department, Lordship. Then an advertisement was issued on 2013, Lordship. Their Lordship for the post of supervisor storekeeper, store Lordship. For reserve ST category, Lordship. Being eligible, Lordship, I applied for the post, Lordship. Annexure 1 is the advertisement, Lordship. There was only one post. Page 15.
The petitioner belongs to Assam. He is from Assam.
Lordship, he is from,
No.
at that point of time, he was working here under project Vartak, Lordship.
And this he is still working. Still working. Madam. Working as what?
May I assist my lord with permission?
Whatever you do please make it short and simple.
Yes.
Yes.
My lord, this what happened, my lord. He is a storekeeper technical of Border Roads organization. And there is an advertisement in June 2013 for the next higher post of store supervisor. It is meant for the ST candidate. So 5 candidates applied, 4 were outsiders. He is the only departmental ST candidate who sat for the competition.
4 were outside the department.
Outside the, because it's an open advertisement.
Directly.
Only one post. But why he appeared, he chose to compete because there's a lot of stagnation in the department entirely. What happened, the exam was conducted in November and then result was out. And the first candidate, my lord, that is of a name Kishore Akhtar. Kishore Akhtar was number 1. He, my lord, he could not meet the second medical chance also for his selection. On which date, my lord? That is on 22.
Where is the list of selected candidates?
List of selected candidates. List of selected candidates, my lord, I annexure page 26, annexure 2, my lord. Annexure 2, page 26. Kishore Akhtar is number 1, my lord. And petitioner is number 2, SKT Sanjay Kumar Shaw. He's a ST. Right? So that, because she failed in 22nd of February 2014. Kishore Akhtar. He medically got unfit. 26th February 2014. Well, this, when the petitioner found that there is an accrual of right, as my lord rightly observed, there
is no accrual of right.
No, my lord, no, what he kept. Okay, I withdraw myself.
There is only protection against discrimination.
I withdraw from my statement, my lord. What happened? He kept on writing, but whether I should be considered or not. Because being number 2 in the merit list. They did not inform till 2015. And 2017 only they intimated, yes, the Kishore Akhtar has failed in selection. And in the meantime, there's a communication from the department. Then the petitioner says, what happened to the vacancy? He says, we have converted the vacancy to the TPC vacancy. I have annexed, my lord, but my lord, without amending their RNP rule, with due notification.
What is the relief you are seeking today?
My lord, I am seeking now, my lord, what is the beauty of the case, my lord? In the meantime, he has been promoted to the next higher rank, 20th June 23. So my limited submission and prayer before my lord, my antedate seniority should be considered, because that, why my lord? Why my lord? There is certainly law point, question of law, my lord.
When was he promoted?
Pardon, my lord?
When was he promoted?
Now in 20th June 23.
So you want this promotion to have effect from the date on which the vacancy?
It fell due because there's a communication and there's a question of law is there, my lord. There is a Supreme Court judgment is there.
Please hurry, please conclude quickly. I have to deliver.
Yes, I'll just finishing, my lord. So what happened, my lord? He just kept on praying. They say,
where is his order of promotion?
Order of promotion, my lord, I just sent it.
This is not a part of it.
Yes, just now.
Yes. Take down the order.
It is in normal course, not through DPC, my lord.
So where is your prayer in the writ petition regarding seniority?
Yes, my lord. Yes.
Yes.
My lord, my interim protection is there. One post has been kept vacant by the interim order. Order dated.
The prayer you are making now, is it a part of your writ petition?
Yes, yes, my lord.
Where is it? Please read it.
My lord, I read page 11, my lord. I draw my lord attention, page 11. Issue of writ order or direction in the nature of mandamus.
Mr. Das, please understand, you are consuming the time of the court. Your writ petition was filed in 2019.
Yes,
right. There, your grievance was that you should have been appointed in the post of store supervisor pursuant to that process, which was started by the advertisement notice issued in June 2013.
Yes, ma'am.
When this writ petition was pending, you have been regularly promoted on the basis of DPC.
I have not been promoted before that, my lord. Only I got my promotion in this date only.
Correct. So now you are a store supervisor.
Store supervisor.
Correct.
Yes.
You are asking that this promotion given to you or notified on 20th of June 2023 should date back to 2000.
No, my lord.
Then,
my lord, I humbly submit that was a case of open advertisement. This is a case of promotion to departmental channel.
Right.
So there's a difference.
So what is the relief you want?
Relief, I say, if I am considered with reference to my right, so-called right, my lord, I say so-called right, my lord will decide, that was due on 26/2/14, being number 2 in the seniority list of the selection, my seniority will be ahead of other because of reasons. I tried my level base and competed with the outsider and became number 2 in the seniority list. One, my lord. Second, my lord, what happened? They replied that yes, vacancy is kept for 1 year. Agreed, my lord. There is a settled law. What they did, my lord, in the same advertisement, 3 Hindi translator, my lord, they were appointed in 2017. Of 2013 vacancy, as my lord rightly observed, what is the prayer and how I can claim that thing. They have appointed 2017. In my case, they say, first they say, one, yes, DPC vacancy, direct recruitment vacancy admitted to converted to DPC vacancy without amendment of the recruitment rules as with a reference to Article 309. 1, 2, my lord. They say there is no requirement of you because of certain changes in the organization. Some decision he'll tell, my lord, that I beg to point out that point also. They say that staff is needed required. Yes, my lord. I am quoting a judgment, Supreme Court judgment, and that I have written in my writ petition. I have highlighted in the writ petition the salient part of the judgment. I beg to read the judgment, my lord. That is page 9, para 10, my lord. Para 10, my lord. It says, my lord, I read, my lord. The judgment is Sichitto Tirumul Institute of Medical and Technology and another versus M. Pushkaran. SCC 448 has stated in para 18, my lord.
It's possible. Copy.
Judgment. Para 14, my lord. Para 18. I draw my lord's attention to para 18. I read, my lord. The para 18. The application of law would therefore depend upon the fact situation obtaining in each case. The judgment of the High Court in view of the above-mentioned authoritative pronouncement cannot be said to be perverse. This respondent was to be offered with an appointment at a point of time. No policy decision was taken. There was no reason not to offer any appointment in his favor. Even the purported policy decision was not in their contemplation. We therefore do not see any reason to interfere with the impugned judgment. My lord, my humbly submit, my lord. If there is a stumbling block in not appointing the candidates with reference to the advertisement of 2013, they should not have appointed the Hindi typist in 2017, my lord. One. Second, most important point, my lord. this in there also, that particular date,
Yes.
that is on 26/2/2014. Neither they have decided nor it is under contemplation, because I have referred the letter in my. I am reading from their the counter only, my lord, what they have annexed with reference to the said argument, page 13, my lord. Because this is the argument they have labeled only for me, not for Hindi typist. Page 14.
So your argument is that the advertisement issued in 2013 for
My
Hindi
lord,
typist.
yes,
That was
same
given,
advertisement.
that was given effective in 2017.
70.
Mr. Das, the reason why I will dismiss this writ petition, I'm telling you, this is the law. You look up it, it will help you in another case, not here.
Go down, my lord.
The only protection or enforcement that you have in these matters is if the person below you was appointed, then only you will get a right. Otherwise, even after completing the selection, after publishing the selection list, it is open to them not to appoint anyone.
Agree.
Yes.
Indefeasible right, as my lord.
You
has
don't
right.
have any right to claim.
Indefeasible right.
Only protection is against discrimination.
My lord, how the Hindi typist,
That
logic, that is not.
We are not concerned.
Now, what the right logic? I draw just for a moment. I read 8 January, R1, page 13 later, my lord. Just for my lord's information only.
Of the affidavit.
Of the affidavit, counter affidavit, my lord.
Yes.
Page 13. The logic they have put to my lord. I finished, mostly finished, my lord. I read page para 3, I read.
Yes.
It is also brought out that the projects have recently surrendered certain units due to handing over NH, National Highways, my lord. Para 3, my lord. It is also brought out that projects have recently surrendered certain units due to handing over of National Highways to NHI, National Highway Authority, and State PW.
This is internal page.
Yes.
Running page 13.
Internal page of the affidavit, my lord. 13.
Yes, page number, printed number.
13, my lord.
Annexure R1. Para 3, my lord. I read, my lord. It is also brought out that projects have recently surrendered certain units due to handing over NHAs to NHI and State PWD. The proposal for keeping these units under suspended animation UPP under posting plan after considering redeployment is to be finalized, my lord. So though they have written on 8 January 14, it says is to be finalized.
All right.
So to sum up, my lord,
yes,
my salient points are there. They have stated that the vacancy has been converted to the DPC vacancy. There is no vacancy for the open candidate. 2, in the same advertisement, they have reappointed. It is a question of reappointment for the departmental. Reappointed to the Hindi typist in 2017 after the long delay. My lord, when the cause of action arose, my so-called right accrued, there was no decision taken, not even contemplated in the subject matter, whether there will be under posting plan or otherwise. And even in 4, in 2017, my lord, only they disclosed to my right to information, yes, the vacancy fell in 2014. Before that, they just made it a secret affair. This is my respectful and humble submission.
My lord, 1 minute. Yes.
My lord, advertisement of June 2013, there is a clause, my lord, vacancy are liable to be increased or decreased, my lord, without any further notice.
Where is the advertisement? Annex?
Advertisement annex in annexure 1 of petition, page 14, my lord. That relevant clause is at page 17, my lord. Clause 1, small p, page 17 of the petition. Vacancies are liable to be increased or decreased without any further notice.
This is clause?
Clause 1p, my lord, page 17.
P, my lord, small p.
Yes.
Small p, my lord. Without any further notice. My lord, what happened? Yes, Kishore Ashtar already selected, my lord, but his my lord, candidature was my lord, cancelled due to medically unfit, my lord, on 26/2/2014. Date is relevant, my lord, 26/2/2014. But prior to that, my lord, my annexure in already, my lord, gone through that annexure 1 of the affidavit, my lord. We have the information from the higher authority on 8 January 2014. 8 January 2014, that because of some portion of it was given to the NHI and the state PWD, so not to appoint any further until further direction of the authority. So my lord, as per the, my lord, that instruction, my lord, dated 8 January 2014. Already, my lord, a decision was for the timing was taken not to appoint further. Subsequent to that, my lord, Kishore Ashtar, my lord, cancelled. So we have the instruction on 8 January 14. Subsequent to that, my lord, 26 February 2014, his candidates are cancelled. So at that time, my lord, he was informed, my lord, annexure 3 of my affidavit, my lord, page 15, 21st November 2014. The petitioner was informed, my lord.
This is the last item.
Last item, my lord, only 2 minutes, my lord. Yes, my lord, page number 14, my lord. 21st July 2014, page 14 of the affidavit.
Yes.
The petitioner, my lord, informed, my lord, as per the intimation received from GRAFE, the holding strength of supervisor store departmental is surplus in view of no induction upgradation from the waiting list for the above post against so has been done. So, my lord, because of that, my lord, we have the instruction from the authority, my lord, and it is notified in the, my lord, advertisement itself that it will be increased or decreased. And my lord, as per the, my lord, policy, my lord, recruitment policy, 20% from the, my lord, direct recruitment and 80% from the promotion. So he is doing that, my lord, already doing the job.
My lord, 1 minute I'll take what my learned friend has stated in annexure R2 and R1 is contradictory. In view of the fact, I have read the R1, which said is to be finalized, my lord. No decision was taken or was to be taken or had been taken, my lord. So my only limited prayer before my lord, if he being an ST candidate, if he is given some seniority, though he has had to face the, the border rules, 4 years service in the peace area, enter 30 years service in the border areas, they don't get an opportunity to appear for the exam, my lord. It is a uniform force. There is no union. There is no redressal of given. My lord, still the petitioner ventured and appeared. If my lord appreciates and is kind enough to give him some candidate seniority, it will be a moral booster to the people of this, because since they do not air their grievances either to union, they cannot avail the legal justice system. Since he was posted in Tejpur, somehow he could manage, and that was after so many time. This is the practical difficulty of the people of 34,000 people of this organization who are doing the very good
You were
work.
earlier serving the BRO.
Border.
Yes.
Yeah, that's
As a
very
matter,
evident.
what is another is mortality rate.
Very evident, because your submissions are not based on law but on emotion, which is understandable.
Yeah, mortality rate is 10, my lord, every month.
But what to do? The courts and judges will have to go by the law.
My lord,
and the prayer you are making,
yes, so my lord, I have cited the
completely impermissible under the service law jurisprudence.
My lord, I have submitted the Supreme Court decision, and what my learned friend has stated in R2 and R1, that communication, that is totally contradictory. R1 says yet to be decided by Chief Engineer. That point, my lord can put. Yes. Only limited prayer for anti-seniority. That's all. No pay and allowances, no consequence.
Judgment.